Further hearing the appeal, the king on the application of Pearce and others against the Parole Board of England and Wales.
Mr. Rule, I'm sorry that an IT problem seems to have delayed the start today. If you need an extra 5 minutes, you can have it.
Model, I'm very grateful, and I suspect, predicting poorly, that I will need the extra 5 minutes. I'm very grateful for the indication I may have it. My Lords, just by way of agenda for my submissions, with the time remaining to me, I propose to attempt to cover the ground, firstly dealing with the concept of facts, secondly with the fact of an allegation, thirdly with the application of fact-finding by the Parole Board through both case law examples and also worked examples available to the court, in a manner of achieving fairness in its operation and achieving public protection. Fourthly, deal with the REH line and family case law that you have. Fifthly, the SIAC, Special Immigration Appeals Commission line of cases. The Parole Board guidance, sixth. Seventh, the Court of Appeal decision briefly, although I've summarised that in the case and may rely on that by the time we've reached that stage. And lastly, may try to assist the court with some attempt at legal classification of the error that we submit is present in the case, bearing in mind the issue that the appellant has raised. My Lords, I had mentioned yesterday that I would go to the last of the criminal line of cases. I won't for sake of brevity, but that case is available, the Farrar case at page 1582 following, which was the case in which the Newton hearing had been wrongly held. But the only point to draw attention to further than that is that other facts could be relied upon nonetheless. So even if the allegation could not be relied upon in that case, the other facts were relied upon. An attempt to minimise role, paragraph 21 on page 1589, 1589, an admission of unusual interest in young boys and inappropriate contact with them, paragraph 25, Roman numeral 1 on page 1590, and a lack of understanding or insight in that following paragraph, Roman numeral 3 and paragraph 27 on the same page, 1590. Turning then to the agenda for my submissions today, on the issue of facts, you heard submissions yesterday from the appellant that it's not helpful to define the dichotomy as facts and non-facts, and an argument that fact-finding is artificial because there's rarely any certainty to the issue that the fact-finding is applied to. In answer to a question by my Lord Hamblin, the Parole Board accepted in its case that there would be no legal obligation for it to undertake any fact-finding or to establish any facts under its policy, provided there was some basis to it. I draw attention, if I may, to some difference potentially between the way in which the courts have used the term some factual basis, particularly in the case of Morris, which we will come to, and the way in which the Parole Board posits the question of law for this court. Could I invite the court's attention to the issue as identified in the Statement of Facts and Issues, which you find at page 69 of the core bundle. That issue at page 69, paragraph 22, subparagraph 1, is defined in two ways. The first, the proposition of the respondent, first respondent, and the Court of Appeal, A, must base its assessment of risk on facts established on the civil standard. Or B, which is the case posited by the appellant, may take into account allegations which it considers relevant, which have some evidential basis. And I draw attention to the word evidential rather than the word factual, as it appears in the issue. That is repeated at the beginning of the appellant's case, over on page 71, paragraph 4. The Court of Appeal in these proceedings identified that it may be the Parole Board uses the phrase interchangeably of some evidence, some evidential basis, and some facts or some factual basis. The factual basis dicta can be traced to Morris. The some evidential dicta doesn't appear to originate in any of the jurisprudence, so far as the Parole Board proceedings are concerned.
May I just ask you to please clarify for me one point? Is it your understanding that this is concerned with a need to have some facts and they must be established to the civil standard, or is it that insofar as reliance is placed on facts, then those facts must be established to the civil standard?
My Lord, I may not have understood the question entirely, but if I posit it this way, the distinction I draw is between evidence and fact.
Yes.
So the evidence is that which can be considered. Each piece of evidence is there. It's before the court admissible evidence to be weighed together to draw conclusions as to fact from. In doing so, you can arrive at some facts or no facts, but you are moving away from evidence towards facts. You are taking conclusions from the evidence as a whole. Having taken those conclusions, you have a factual basis on which to make your decision. But you are limited to that factual basis. That factual basis does not translate into something bigger, wider, different in terms of allegation or other phrase that might be used for the other fact that hasn't been proved, to which it might have some relationship.
So you're saying there have to be findings of fact?
Indeed.
The mere existence of evidence on your case isn't enough. There has to be an exercise of the analysis of that evidence.
Yes.
And the coming up with fact finding.
Indeed, my Lord. And for the avoidance of doubt, if the term used some factual basis is used as a gateway to reliance on non-facts, we submit that is incorrect. The proper factual basis is limited to the facts as found, and that is what you factor into your decision making.
What is an evidential basis?
Well, my Lord, this begs the question. What is sufficient to be an evidential basis and what is insufficient to be an evidential basis, quite apart from the law having grappled with what is a fact or what is the standard to establish a fact. We're in danger, in my submission, of eliding separate points, separate facts, separate matters of evidence and fact, and treating them interchangeably then undermines the process in which you receive evidence and find facts.
I mean, I raise the point because it's clearly not evidence as defined by rules of court.
No. In this case, what one might term evidence would be information, because the rules of court permit information.
That's the word used in the statute.
Indeed. So the consideration, whether one calls it a consideration of evidence in the way one usually uses that term, or consideration of the information before the judicial body, either way, that is the first stage. We then submit that it's the inevitable use for that material is to move to the second stage of finding the facts.
The Act doesn't say anything about finding facts, doesn't use the word fact. It uses the word information. So what is the statutory basis for saying that the Parole Board must make findings of fact on a balance of probabilities and rely only on those facts?
We submit these are two different things. The Act is talking about the admission of material that goes before the Board. What can be placed before it? That's the reference to information.
It has to consider it. The Act says it must consider the information.
Indeed. But considering it doesn't then answer the question of what its task is. One has to move to Section 28. Once you then consider what the task is of what to do with that information, where Section 28 is concerned, that task is to be satisfied, and it is to decide whether it is necessary on the material. And so that is, or is not necessary on the material, but to form a conclusion, a satisfaction, which in some of the case law that deals with these points, the VH line and others, we see that reference to being satisfied because it draws a distinction.
So you say it's implicit in the use of the word satisfied that there must be findings of fact on the balance of probability, and the decision must be limited to those facts, quote unquote, as so found.
My Lord, not only on the basis of the word satisfied. We say it's implicit in the statutory section, but that is both either or both of the use of the term satisfied, draw a distinction between reasonable grounds for suspicion or other matters as might be expressed. But that word has relevance, we say, in the dicta that one finds on the topic. And the other point is that it is necessary. So it's not asking whether it's a risk of something or whether there is a risk.
There's a risk of something. isn't it? I mean, it is, insofar as you're trying to predict future behaviour, it's a risk assessment.
Well, the question to answer is the necessity. And answering the necessity, you form an evaluation of the risk. But the risk is a fact in the future that you are finding. What you are not finding is there's currently a risk it's necessary. You're finding there's currently evidence upon which to conclude, having found the relevant facts, that is a basis.
Sorry, you're saying all that, but I'm trying to understand how you find it in the statutory language.
Well, my lord, the answer I'm trying to give inarticulately is that there is a distinction between the future prediction, which is the risk which makes it necessary, and the fact that it is necessary, which is what you find in the present material. So you're looking at the future risk, and one is making a prediction, but you are doing that on the material available to you that demonstrates the necessity exists.
Well, you seem to be working on the basis that the parole board has to establish that it's necessary to keep the person detained. I mean, the test is precisely the opposite. The parole board has to be satisfied that it is not necessary for the protection of the public that the person be detained. I mean, it's a very different test.
Well, my lord, that's the ultimate question, but the question is not determinative of how you answer that on what material. You are properly entitled to answer that question. So if you are answering it by reference to facts, you have a basis upon which you are deciding that you are not satisfied, that it is no longer necessary, to use the exact word. But the way in which that language is used in my submission is not apposite to place a special onus on the prisoner to prove a state of affairs.
It's quite clear there's no burden of proof here, but the exercise that the parole board is statutorily required to undertake is to look at the information before it and decide whether it's satisfied that it is not necessary to continue to detain the prisoner.
Yes, and the case law suggests that is given a certain level of gloss or explanation, that you look at the question whether there's a no more than minimal risk, and that is the way in which the board may express itself in addressing the question of Section 28 and whether or not it's necessary in answering a relatively low threshold.
Richard says it is a risk assessment towards that end, towards establishing the absence of necessity.
Yes. Well, my lords, if the argument based on deciding the currency of necessity, the is necessary point, doesn't find favour, certainly I rely on the satisfied element to it. What is clear, and beyond any argument about the language or any particular balance that it provides, is simply that it doesn't adopt what would be an obviously lower threshold of establishing that there is a suspicion or a possibility of a risk, rather than finding the actuality of that in the proper manner.
Your answer to Lord Richard's question, if I've got it right for my note, Mr. Rule, is you find the necessity, you find the demand for found facts in the language of the statute, first of all in the word satisfied, and second, having thought about it, in the expression is no longer necessary.
Yes, my lord.
Because is no longer necessary, you say, postulates a factual situation. Is that it?
Yes. That is the literal, a current factual situation upon which you draw the prediction. So you're inferring the future risk from those facts.
I'm just wondering why that isn't simply assuming what it seeks to prove.
Well, my lord,
it's a very difficult question to answer always.
Well, when I come to the cases that deal with the Re-H statute, for example,
yes.
The Section 31 Children Act statute, these are matters that the court found of relevance. The fact that it refers to being satisfied, the fact that it refers to is rather than might be or possibly be, those matters were regarded as relevant in the interpretation of what was implicit in the statutory function.
Right.
And that is all, of course, dealing with literal construction. There is also, of course, a very strong purposive construction point, which is that this is a test ultimately deciding between liberty and between public protection. It is entitled to give preponderance to public protection in that test, but the function of applying that test is to determine between liberty and preventative detention.
Are you going to be saying to us as well that you gather the demand for found facts in the concept of common law fairness. Is that going to be your submission?
Yes, my lord.
Right, well, we'll deal with it separately, but that's coming, is it?
Yes.
Okay.
So in my submission, the process that is fair, that is required by common law, but also Article 5.4, is a judicial one which involves establishing the facts upon which you make your judicial decision.
Right. Okay.
On the issue of facts, the law that we submit recognises only two standards for proof of facts which a judicial decision rests upon: the criminal standard and the civil standard. There is no other potential for finding facts. The Parole Board submissions yesterday suggested that the question whether facts have to be established on the balance of probabilities, if right, makes probing difficult, which is the outcome, of course, of the War Boys' decision, that it's entirely proper to probe the prisoner with the information. But that is, with respect, not an argument that bears weight. The probing is part and parcel of the process, which is perfectly permissible, of considering that information. So within that process of consideration, you're entitled to invite the prisoner to deal with the allegations or the information you've received and draw conclusions of fact from his or her answers. The question of what is a fact has received attention in the context of the Parole Board's decision-making, precisely because it bears an importance in what is within the function of the judicial body and what is the evaluative discretionary exercise or the judgmental exercise to be taken based upon those facts. And we can see that in one of the cases in the bundle and in our submission. This makes it clear that that distinction is relevant to the two-stage decision-making process, receiving the information and weighing it up to draw the factual conclusions at the first step, and then at the second step applying your mind to the statutory test or applying your mind to the evaluation of future risk, which is necessary to answer. And the importance of keeping that distinction in mind is demonstrated by the case of John and the Secretary of State for Justice, which you find at page 1127 and following. This case is in the context of the board's decision-making, where it can both decide on the question of release and also recommend whether or not the Secretary of State ought to move the prisoner to open conditions or Category D security conditions. And that's important because the Secretary of State, as we've seen, is bound by the judicial decision on release, but is not bound to agree with the recommendation. He receives that as advice from the judicial body. But the cases have not allowed the position to arise where the fact-finding process and the parole board's function is in any way undermined through the fact that it is providing a fair process, a hearing, making the findings of fact, but ultimately the decision about where to place the prisoner remains with the Secretary of State. And it does so by drawing the distinction between what are the facts that the board has found and what is the evaluation the board has completed under its predictive assessment. The latter being a matter the Secretary of State can decide to disagree with. The former, he is not entitled to disagree with. The facts are the facts as the board finds them. And so, in that regard, the relevant dicta you can see at paragraph 40, firstly, on page 1135. Considering a divisional court decision in Hindawi, the court deals there in the indented paragraph with the dicta of Lord Justice Thomas and Nicola Davies J, as they were, who noted panels carry out the work operating in a manner like a court, sifting and analysing the evidence, and when there is an oral hearing, making relevant findings on disputed issues, which could not be resolved by review of the papers. And continuing in the indented paragraph 58, still paragraph 40 of this judgment, it is, in my view, necessary for a clear distinction to be made between findings of fact made by the Parole Board panel and its assessment of the risk. The findings of fact in that case, it could include things like the credibility of the account given, other matters that are particular facts in that case. And there's some discussion about this over the page on page 1136, paragraph 47. Drawing the key distinction between, on the one hand, the findings of fact made by the board, which the defendant would only be able to depart from with good reason, and on the other, a matter of evaluative assessment, which he must take into account, but can give weight as appropriate, and other matters that he might consider appropriate. So the distinction is recognised as an important one, legally speaking, because of the role in which the board plays in those decisions, in what are the facts, and in separately, and the separation of the matter is important, the evaluative exercise.
I speak only for myself, Mr. Rule, but I don't have the slightest difficulty with the difference between fact-finding and evaluation. What I struggle with is why you deduce from the fact that there's a difference between them, that before you can start on the evaluation, the only material you can use are found facts. Why does it follow?
Well, my lord, the alternative case is that the evaluative exercise is entitled to depart from the first exercise. So the first exercise...
It doesn't follow at all.
Well, my lord, depart in this sense. If one has accepted the proposition that a fact is to be found on a standard of proof, it is a probability standard applied, the civil standard, which is what I'll seek to demonstrate the cases have thus far always said. And on that basis, you have found your facts. The other matters are to be disregarded as not being factual.
So is the core of your submissions. I understand that.
But my lord, the contrary is that they're not to be dealt with in that way. They remain as relevant to what is actually the decision. The purpose of the whole purpose of the statutory provision and of the decision making of the board is to decide whether or not to release. It is to decide the statutory test. Now, if at the second stage of doing that, at the ultimate decision, you're entitled to say, although at the first stage I was not satisfied, even on the low threshold of the probability of an event having happened, despite the fact it may in fact be a criminal offence that's being alleged and none of the safeguards of a criminal trial or any of the other matters, disclosure and other things, but nonetheless we're forming a view, for public protection reasons we're entitled to do that. But having undertaken that task and not being able to say that probably happened, you then have regard to what may not have happened, because you haven't found it probably did, but you factor it into your evaluation of risk.
Yeah.
And that's where we say inevitably the two things go hand in hand, because you cannot divorce the process. Its function is to inform the second stage. It is to inform the evaluation.
All right, thank you.
And we submit it's the only fair way to do that. Otherwise, you are speculating. You are allowing the smoke to remain in the room and make your decision through that lens.
Facts that haven't been found to the civil standard can't be taken into account in the evaluation, but other matters, for example, a psychiatric report, may probably be taken into account because that's the expert's opinion, which
Yes,
the board
so that's a fact. The expert's opinion is that you are a risk. Take that into account.
Well, it may not express it in terms of a risk, but the expert may give evidence in the report expressing a view about matters relevant potentially, at any rate, to the ultimate decision the board has to make.
Yes.
But they're not primary facts. It's a report. It's a report expressing a view.
I accept it's an expert opinion taking from the primary facts or other matters that the expert has considered in the round. The expert has formed a view, usually having interviewed the prisoner, having conducted potentially specific tools that are used for the process, which operate on the basis of understanding what has happened and the assessment. And the assessment, the interview process, obviously reveals things about the individual which can be relevant to their risk, highly relevant. But this all goes to the purpose of the parole board in its functioning, being to look at the risk as it stands now. It's not actually designed to...
I'm sorry, I'm just trying to pin it down in terms of your fact analysis. Where do you put the expert report? You would say that the report is a fact, or the matters to which the experts referred must be facts or are facts?
The facts that the court, the parole board as court, will operate on are those taken from a review of the expert opinion. So I would describe as a fact the expert has said, has assessed, concluded that you pose this risk. That's perfectly obviously relevant material that goes through. Whether it's primary fact or secondary fact or opinion, I certainly accept its relevance, and it's part of the process of forming your global assessment of risk. Yeah.
Well, it's likely to be a description or an opinion, isn't it? This man's attitude to women is as follows: this man has a personality disorder. This man is obsessed with something or other. Is that a fact? For your purposes, I suppose you'd have to say it is.
Yes, but I don't think there's any difficulty in submitting it's a fact, but if wrong about that on a technical basis, it's relevant. The relevance of it being that the experts conducted the assessment, and there'll be many aspects that have to be assessed, but there will be in particular focus on the risk factors that are identified and the level of risk that exists in the prisoner on the expert assessment. So there's the fact that the assessment has reached those conclusions that is relevant to be taken into account.
Sorry, the fact is the statement that the expert is of that opinion. Is that it?
The opinion reached is relevant. Yes, those are the facts that the board is operating on. You have before you the opinion. Either the expert says you are a risk on this basis, or you're not a risk on that basis, and specifies X, Y, and Z, which you take into account.
Well, it may not be directly a question of risk. The expert may not address it in those terms. He may simply describe the man's psychological makeup, mayn't he?
In a theoretical world, yes.
Well, and in practice, I suspect. All right. Anyway, you say that the psychiatric opinion is itself the fact is itself a fact because it's a fact that it has been stated.
Yes.
Okay.
I mean, the psychiatrist may conclude that the prisoner poses a risk, but that would have to be based on assessments of his attitude, as my lord has said, perhaps to women or something of that sort. So there is, in a sense, his opinion is stating, in his opinion, he has this personality trait.
Yes.
I mean, that's a fact. He has a personality trait. Supposing the prisoner also has a psychiatric report which comes to the opposite conclusion, says he doesn't have that attitude to women. How does the board deal with that?
You're weighing and deciding the weight you give to all of the evidence as a whole, and you're choosing between. Sorry, Mark.
Yes, right. I mean, if this was a civil trial, the judge would have to weigh the competing expert evidence and accept one and reject the other.
Yes.
Is that what you say the board has to do?
It's what the board has to give reasons for rejecting expert opinion. That's established.
Yes, well, basically, I prefer psychiatrist A to psychiatrist B for the following reasons.
Yeah. That's what in practice happens. It will list the evidence. It will list the evidence from each of the witnesses, including the experts, psychiatrists or psychologists, and it will form a view and it will describe, as in fact they do in Mr. Pearce's case, because the psychologist, I think it was, reports were that his risk factors were all known and he'd been addressing those, because we're talking about matters from the past. But if the risk factors, as the psychologist said, were already known and have been addressed by the courses he's undertaken and the assessment that I give, then they form a view about whether he's addressed those and has reached a certain risk level. So there's no difficulty with the board disagreeing with the expert reports or relying upon them. They're matters of weight for the information it's received, to put it all together and decide what it concludes. But its conclusions are ultimately factual. Do we accept that you are that risk or not? Do we accept you have the personality disorder if there's a dispute about that, for example, or do we not? And it takes those matters forward in its assessment. So if it's preferred one witness and one expert opinion over the other, it's entitled to say we will operate on that basis.
So I see. Thank you.
My lords, you will see some examples of what are facts in the John case, and rather than my inadequate answering of various postulations, we can see some concrete examples of where the courts had to grapple with, is this a fact or not, in a particular case where there is expert evidence and other matters before the board. So there's more detail about that at paragraph 49 on page 1137. I don't know, my lords, if you managed to finish paragraph 47, I refer, if I may, to that on the matter of principle. And the other paragraph that might be worth just mentioning to the court is paragraph 42, summarises a case of Noy in which the similar question had had to be asked again. What were the findings of fact that the board had made? My Lords, may I then turn to the air raid example? I don't propose to take REH out of term, but to deal, if I may, with the air raid example of that warning in the course of the Second World War that Lord Brown-Wilkinson gave, which you referred to earlier, because that, of course, allies to the suggestion that the fact of the reports themselves, the unconfirmed sightings, was the relevant fact, not the truth or otherwise of whether they were German planes that were about to raid or were in the course of raiding this country. There are 3 points that I make about the air raid warning example.
You just give us the page, please.
My Lord, that appears on page 536, at letter H, to 537C. My Lord, I'm perfectly happy just to remind the court of that, perhaps, if I invite your attention to that then. So that's page 536 to 537.
Presumably you say, well, that it's not an example of a quasi-judicial decision.
That's my third point, my Lord. You're ahead of me.
A long way off the deliberations of the Parole Board.
My Lord, entirely. That is ultimately, as I say, my Lord.
You have a number of points on it anyway.
Yes, perhaps I'll just develop the first two, if I may.
Yes.
We'll get your 3 points in the order you wish to present them.
Thank you, my Lord. So the first is what is the question that is being asked by the particular scenario, and that is that there is a risk of an air raid being in effect, not a question as to whether there is a fact of an air raid being in effect at that time. It doesn't ask for proof of past or current air raid. It asks for the risk of an air raid being in effect. And it may be presumed that the precaution is in use rather than necessity to be shown for any use. There's no balancing exercise. There's a precaution in the use of it. Nor is it asking the question whether you infer a future position, a future air raid, from an actual air raid having taken place.
Is that point 2 or point 1?
This is still elaborating on point 1, really. And so that distinction, we say, is important when one turns back to the differences, as my Lord Richards was expressing, the differences between the judicial test here and that. The second point is an analysis, really, of what the relevance are of those particular facts, of those 5 unconfirmed reports, in the context of 1940s Britain. And before I attempt my own submissions on that, may I place some reliance, if I may, on Baroness Hale in the Re B case, which my Lords can see at page 796. This is the Re B case dealing with the REH line, in which the court upholds the majority there, and this example that Lord Brown-Wilkinson had given of the air raid is referred to in short terms by Her Ladyship there at just below letter B on page 796. So you have contextual facts which were available in which to establish weight and relevance of a fact of the report coming in. And if I might elaborate, probably doing no additional service to Her Ladyship's comment, but if I might elaborate, the air raid warning situation includes firstly that Britain was at war, secondly she's under constant threat of air attack, thirdly that there were 5 unconfirmed reports received, though those would have to be weighed in our respectful submission with further facts, which is the timing of the reports, So are they enabling an assessment of aggregate weight, or are they not? If they were inconsistent in timing or inconsistent in location, the fact of those reports would not assist in a fact-finding exercise of any risk, even if it's a very cautious precaution rather than actuality of risk that needs to be looked at. There'd still be a question of temporal or geographical location, which would be relevant to whether or not 5 unconfirmed sightings in fact did indicate there was a risk that an air raid was in effect at that particular moment. And a contextual knowledge, lastly, in relation to that, if 5 unconfirmed sightings on a day in 1940 meant that it was consistent with a day on which there was not an air raid, whereas 300 unconfirmed sightings was consistent with a day on which an air raid was taking place through 1939 or 1940 earlier part, then that would place a context on unconfirmed sightings as a fact that those reports had been received within the wider information and facts that were known to establish what weight they provided in terms of any relevance. So we do submit that the fact of the reports themselves would not bear any relevance aside from the contextual facts, the other facts that give them a relevance that you can place them into, even in the context of air raid warnings and the precautions that would be in place. And the third point relating really to the judicial process, as my Lord began with, is that an approach of that nature may well be one of mud sticking or of smoke without fire, and that may be appropriate to air raid warnings, but it certainly isn't appropriate to determining liberty or judicial decision making. So those are the 3 submissions that we make in relation to the air raid warning example that the Parole Board has placed reliance on. I deal then with something that the court raised yesterday with my learned friend, which is the fact of allegation and whether the fact of allegation itself, in the context of Parole Board proceedings, bears relevance and weight as a matter to be considered. It's not, in fact, clear that the court is invited to depart from prior decisions on this subject, and we perhaps urge an element of caution if the court is being asked to depart from what has been the established position in the case law without the parties' cases having addressed that as an issue. It's no part of the Parole Board's case as set out, and it's no part of the guidance as set out that an allegation itself becomes a relevant fact that can be taken into part. And that's when you get
but why shouldn't, in principle, why shouldn't the allegation be a relevant fact?
Because what is probative, my lord, is whether the prisoner has engaged in conduct which is relevant to risk. What is not probative is whether or not a complaint's been made itself.
But if the complaint has been made by the alleged victim, I mean, it is that self-same complaint that will eventually be repeated at trial and will be no doubt tested at trial, but it will be essentially the same allegations being made, and in the context of a trial that will be highly relevant factual evidence. Why is an allegation not a fact?
Well, the fact of making the allegation doesn't bear any weight at the trial or otherwise, in my respectful submission.
No, but the fact that someone has said this is what happened to them, and the prisoner was the perpetrator of that matter, is not that person's evidence that happened itself a fact?
The evidence is relevant. The person's hearsay account, even at that stage, whether it's on a body-worn video camera, whether it's a statement, that is relevant. What they've said happened is relevant hearsay to be weighed and to be fairly tested if it's disputed. So there's no difficulty with what is said of relevant fact, i.e. this happened, he did this, she did that, this is relevant to the risk level that you're assessing. They were in a certain location, they did a certain act. Those relevant facts could be established by the complaint itself, by the hearsay complaint. But what is not relevant is the fact someone's made a complaint, because that presupposes whether or not you find that there is any substance to what has been said, or what is said, because the fact of complaint itself is divorced from the detail of what is actually said. You've had a complaint that you were involved in an offence. What does that really tell you, other than that there is a complaint to be looked at? It's the starting point, it's the pistol to start the investigation of what the facts are.
I think you're right to say that I don't think the Parole Board has challenged the assertion that a mere allegation isn't enough, but I do struggle with that concept in Mrs. Justice McGowan's judgment. I mean, it seems to me that it may depend on the content of that allegation and the circumstances in which it was made. I mean, I don't know where this line has developed from.
Well, my Lord, it's not, with respect to Mrs. Justice McGowan, her initiation. It is a line.
It's her interpretation of Delaney, is that right?
Well, it goes back to Broadbent and Mr. Justice Stanley Burnton, as he was. So we submit it's well established and has been applied. Broadbent is a regularly cited case in parole board proceedings. It is well established and ingrained in the process, and not something that we, as first respondent, have prepared to meet, to say that the fact of the allegation itself, rather than the details it reveals.
In itself, that's the point.
In itself, that's exactly the point, my Lord. What it reveals, if there are facts revealed by it, are entirely permissible evidence, or information rather, to take into account, deciding whether it's fair as hearsay to not have a witness, to have a witness cross-examination or not, but then to decide what facts you found from that further information.
Does it come to this, that it is a fact, but it's a fact of no probative value?
Yes. Yes.
But it does rather demonstrate, I mean, that's exactly right, if I may say so, but doesn't it rather demonstrate the difficulty of grappling with the idea of facts and non-facts?
Well, my Lord, my suspicion is a different point. It's dealing with relevance of a fact, or probative value of a fact, or possible relevance.
Right.
It's certainly a fact. A non-fact would be the police told the probation officer there'd been a complaint. When the probation officer looked into it, another police officer said, no, there wasn't. And the parole board accepts the second account. That's the non-fact, that there wasn't even a complaint at all. There was an inaccurate report had come through.
Right.
So that's the distinction. But I do submit as my Lord's. I adopt the point. It's the probative value of that fact for these purposes that's absent. And it is followed, of course, in Delaney. Broadbent itself, I should just make one point, my Lord, given the discussion there was yesterday. That case is set out at page 1032. You have reference there. At paragraph 18 to the fact that the parole board hearing was to be the same day as the trial starting. And this goes to the point about adjourning to wait for a trial. And my Lord, I raise it only because I'm familiar with the parole board's functioning at a grassroots level, as it were, and prisoners' complaints generally about delays that they face, and parole board complaints about delays they face. Broadbent was specifically dealing with the point about concurrency, as it were, between the criminal process and the parole board process at that stage, rather than suggesting a general sense to putting matters off. Because the parole board undoubtedly has to follow the guidance and make fact-specific decisions. But unlike, contrary to Chief Coroner guidance, many inquests are put off to wait for criminal trials because they can be. Despite guidance to the contrary, the reality is that a parole board has to function within a reasonable timescale to decide whether or not the person should be provided with their liberty or not.
So does it follow from that although in the particular circumstances of Broadbent, because the trial was imminent, it was perfectly possible for the parole board, or would have been perfectly possible for the parole board, to put it off to wait? In most cases, you can't assume that will be proper.
Indeed.
In which case, what do you do with the situation in which there is a new allegation, not an old one, but a new allegation of something that's said to have happened on licence, and the Crown prosecution is still scratching its head about whether to prosecute the chap or not? It's assembling the evidence. It may, for example, sometimes take the view that whether it does prosecute him or not, depending on how serious it is, but it might take the view, mightn't it, that it would depend on whether he was still in prison or not.
Well, with more serious offences, I think that...
No, with less serious offences.
Yes, with less serious offences, whether or not there's a prosecution is not inevitable.
So what does the parole board do when there is outstanding the possibility of a prosecution? or for that matter, I suppose, a disciplinary hearing somewhere, or something of that sort, should it nevertheless try to determine the facts and preempt whatever other procedures are going to take place, or should it not?
I take my lead from a learned friend, and without being pusillanimous, it is a matter of the facts. That is within the discretionary breadth of the board's decision-making, that it decides on an individual case what is available to it as a whole. If its decision is likely to depend on resolving the facts of the new allegation, then it is very likely to want to resolve those facts. If it has other information, the admission that while he disputes he was aware of the cannabis in the van, he doesn't dispute he's in a van, and has associated with individuals who have been who have a record of convictions or previous police relationships, etc. And therefore, that is a risk factor that the parole board is fully entitled to take into account, because it's not disputed or it's been established by the hearsay without necessity to try it.
What I'm trying to get at, Mr. Rule, is will there be do you or do you not accept that there may be cases in which it is necessary or would be desirable to look at the truth of the fresh allegation, whatever it is, but there is an obstacle to doing it because it would preempt some other potential proceedings?
My Lord, the guidance deals with this, not necessarily the allegations guidance alone. There is detailed further guidance for the board on what it does when it has this situation. The position ultimately is it will depend on the facts as to whether the board does. It is not prevented from undertaking the factual exercise if required on the balance of probabilities through its processes in which hearsay is admissible. But whether it chooses to do so will be one of those matters within its expert judgment on the particular facts.
Well, what the guidance that we are being asked to review says is that there contemplates, I think it's paragraph 16, there may be circumstances in which it will be unfair to the prisoner to embark on a fact-finding exercise in relation to the truth of the new allegation. Now, do you agree that there may be such situations or not?
Yes.
Right. Well, in that event, what's the board to do?
It is able to choose to either adjourn if it feels that's the appropriate decision.
Can't do that, you told us.
No, my Lord, I said it can. My Lord, I am not dodging a question when I say it's all fact specific. If I posit any number of different varieties of facts, I could give you what I would suggest the answer to be, but it would be a matter of rationality for the board to choose whether it follows a course or not on a given case.
But forgive me, what I'm trying to get at, very ungainly, I've no doubt, is whether there may be situations in which it would be unfair to the prisoner to embark upon a full fact-finding exercise in relation to the truth of the new allegation, but it is nevertheless cries out to be taken into account that the allegation has been made. Now, may there be such situations?
Yes, and in that situation, the board would have a choice of either adjourning its decision until it had the outcome of the criminal trial to follow with its own process, or to decide that it could form a view on other relevant material sufficient to decide fairly what its outcome should be. And that wouldn't be ignoring the fact there's an outstanding criminal matter. It would be whether they have sufficient on the given case to form a view.
All right.
But that's why I come back to the fact-specific nature of what I would submit to be the right answer or wrong answer within rationality bounds for the board on a given case about timing for its decision and about what it chooses to investigate. But that doesn't.
The other guidance you refer to.
Yeah. My Lord, there's a very substantial document. I'd have to look. I no doubt my learned friends could assist. If I'm right that there is something, I think there is an oral hearings guide which at least at some stage included some reference to other matters. But it wouldn't be in different terms to this, that it's a matter to exercise cautiously a decision about, in a given case, whether or not it's fair to go ahead and basically have a trial which might involve witnesses, etc., or whether you have some other way of dealing with that particular case.
But I'm still not quite sure about this. If the board decides not to adjourn, are you saying it's got to find as a fact whether or not the allegation, which is currently being investigated with a view to possible criminal proceedings, the parole board has to find as a fact whether or not the allegation is true.
If it chooses to, if it wants to rely on
Either it adjourns. Oh, yes, yes. Have a case where it may be of decisive weight in its decision. You say that if it wants to place weight on it, it must seek to determine on a balance of probabilities the truth.
yes,
Even though it would be unfair to the prisoner to do so. I suppose you put the prisoner to his election in those cases. He's not going to want to give his possible defence an early airing and give evidence to the parole board which could be used at a subsequent criminal trial.
Well, he cannot dictate to the board its process.
Right.
He can submit, or he could challenge the rationality
Yes.
of the board trying, let's say,
Yes.
it's a very serious allegation
I see.
based on one word. That is going to be before a criminal court for trial with the jury.
Yeah.
The prisoner prefers to have the cross-examination of the complainant reserved to the trial so that it is occurring on the first occasion. The parole board is concerned that if the allegation is true, it will have a very significant impact on the risk.
Yeah.
The board's choices at that point are either to adjourn to await the outcome or to proceed irrespective of the prisoner's wishes and submit, we have to look at whether this is true or not because it's important to our decision. We've decided that.
Okay.
So we then look at the facts. Now, how we do that on boards procedures rather than criminal procedures, but so long as we're concerned that we are doing it fairly.
And it's fair because the prisoner has an opportunity of participating even though he chooses not to.
We assume the board has decided that we can fairly try this because we'll go down this route. If it decided it could not fairly try it, then one would expect the only rational outcome would be to adjourn because it would be otherwise acting unfairly. But it wouldn't be obliged to release on the basis that it was unable to fairly try that matter that was determinative. It would be entitled to adjourn and wait. And we see many delays, although I make the point because no one wants to build in further delays than we have to. There are umpteen delays, even in Mr. Pearce's case, as we see from the facts, on trying to obtain police evidence that in fact never comes. So it's not just about trials, it's sometimes about the gathering of evidence for these allegations can take very long time and may be fruitless. But nonetheless, it's a part of the procedure where the board has chosen to look into a matter in detail to make findings about it.
But as I understand it, even if the board were to decide it can't fairly determine the outcome of that particular allegation and decides not to adjourn, it may nevertheless feel it's able to make findings of fact of a secondary underlying nature, for example, that there was cannabis in the van.
Yes. And my lord, exactly. And
Those could be taken into account in assessing the risk.
In practical terms, very often my submission is that the board is able to look at the surrounding facts that are not in dispute, even if there is an issue for trial. As we all know, the criminal offence will have ingredients. Some may be in dispute, some may not.
Yeah.
And it is the ones that are not in dispute that are very frequently of use to the board in determining whether or not it's satisfied there's a minimal risk or not posed by the prisoner being at liberty. So that is, in my submission, a practical solution that is frequently available. But I've dealt with the extreme example and my submission as a matter of principle in the extreme example as well. I hope of assistance, but without prejudice to the practicality in which we submit, as the cases often say about the re-H scenarios, that there's very often other facts that you can look at that would inform your assessment. My Lords, one matter that was certainly raised yesterday in discussion was whether the principle about the fact of an allegation having itself no probative value alters if there are more than one allegation. So we receive the numbers. And basing himself, I think, on Lord Brown-Wilkinson's 5 air raid warnings, or unconfirmed sightings rather, for the air raid example, my learned friend posited there might be 5 occasions a person was present when a terrorist slogan was shouted without identification of the person. Well, there'd certainly be the fact of presence. That wouldn't be an issue that the first respondent takes or the Court of Appeal takes. But if one's dealing with something beyond that, whether or not the person is someone with terrorist sympathies as a fact, whether that's what you're trying to establish, then there is, of course, the potential in the fact-finding exercise, and this is the emphasis I place, In the fact-finding exercise, you have regard to the multiplicity of the allegations. And that's not something that's controversial in the sense that courts are frequently called upon to make global assessments of the findings of fact from the constituent elements they receive. Now, if each actually amounts to, and I'll use the word, although for reasons you will already have gathered, I don't like its use in many ways, allegation. If we're calling it the global macro fact, the ultimate offence, as it were, if you have 5 of them rather than 1, the circumstances in which, when you don't know if any of them yet have happened, you're engaged in the fact-finding exercise for all concurrently. If one looks for the criminal courts for guidance, you have the question of propensity or similar fact coming in through bad character in a particular way in which the similar facts can be probative when you assess whether each one is found to have happened. The term used in the current Crown Court compendium would be cross-admissibility. I think it might have been called mutual admissibility at some stage. But that is, one doesn't disregard in the fact-finding the fact of the multiplicity. And it may be relevant because it rebuts coincidence. One example that's often given. The other is that it shows propensity because you're able to stagger the considerations and place them together. I would urge some caution that the criminal courts insist still that detailed directions are required for a jury in how logically one goes about a probative exercise with multiple allegations being tried and the question of cross-admissibility. So it is an area of genuine complexity in its logical and practical use in such situations. But in theory, there's no reason why a panel of the Parole Board could not self-direct in relation to multiple allegations with cross-admissibility in the fact-finding exercise. But that is all at that point. One then goes forward with what do you do if none of the 5 allegations are shown to have occurred as a probability, even though there was a multiplicity which made one perhaps slightly more incredulous of any defence or account given in mitigation or explanation. You put them all together. On the specific facts, of course, you'd be looking at the level of similarity and whether there was contamination, collaboration, whether the sources were different, the same source, etc. All of those things would be weighed up in finding your fact, whether or not any of those allegations were probable. But if you have not found any of them to be probable and no relevant fact arises within that exercise, other than the allegation, to use that term for the ultimate fact that's relied on, you must disregard it as mere allegations because it's not a fact.
Well, it is a fact, but it's one that has no probative value.
Yes, my Lord say yes. One disregards as not probative the unproven matter. There is, before I leave the multiple allegations point, one thing to mention, which is that it has another relevance if a prisoner faces multiple allegations in their history or in their currency, which is that it opens the door to an investigation of the facts. That was a point made when I was mentioning, I took the court, I think, briefly to War Boys on that point, where Sir Brian Levison was talking about the usual ability to answer a case without having to go into unconvicted record. You have the conviction record, you have the details of the index offences, and you are able to form a picture of the risk from those matters. But in an exceptional case, and War Boys could hardly be more exceptional, of course there's a need to go into understanding those risks by further information than you had obtained just from the criminal record. But that is reflected also in the Parole Board's practice as to whether or not it will be faced with, this is an individual for whom you should be looking, we submit, say probation or police, at a wider information than would normally be the case in the conviction record. And I make that submission based in part on what War Boys said would be the principle, but also on the basis of the Secretary of State's guidance, which you have in your appendix part 2, at page 399 and 398. If I just invite the court's attention, please, to 398, and I'll take it in order. You have an original bold in the text of the letter. Now, this was sent out by the Secretary of State to probation and prison staff in the light of War Boys to explain what should change in terms of preparation of dossiers and information to be given to the board. And you'll see in bold the first commitment that all relevant evidence of past offending should be included in the dossier submitted to the parole board, including possibly police evidence, so that it can be robustly tested in the parole process. That wasn't a commitment that every case should involve every non-conviction on a prisoner's record being brought before the parole board and being subjected to interest. It's still limited to where those involved in the process have formed the view that there may be a relevance. And this is what brings you to the multiple allegations point, because of the likelihood that that in fact does provide some further information of relevance to risk assessment. And that is posited over the page at 399, where the board in the third line talks about offender managers, offender supervisors and psychologists producing their risk assessments in cases where the offender's criminal convictions may not present a comprehensive understanding of the offender's risk, considering carefully whether the relevant evidence from untried allegations is available to provide that comprehensive understanding. We believe it will only be in somewhat exceptional cases that it's necessary to do this. Now, we have not cross-appealed on a question of exceptionality, extraordinariness or anything else. The point is merely one of practical application, that the parole board will be faced with the requirement to look at these matters only in relatively few cases where there is a suggestion to be made, and ultimately be for the board to accept whether that's the case or not, that it may be assisted by this wider information. And the multiplicity of allegations is going to be a factor in whether that is the case. My Lords, a final point in the fact-finding exercise matters, just a brief submission on the Shagang shipping case that we were referred to by Lord Hodge yesterday. Without going to it, the paragraphs within that judgment we were referred to, 98 and 99, so we would draw attention to 97 and to 88 to 91. But really only to make this point, that the issue in that case was about excluding the evidence at the stage of fact-finding, because at an earlier, or our understanding of the issue, at an earlier stage, there had been an admissibility ruling that had not found a proven fact of torture. So that when evaluating the confessions that had arisen, having admitted them because having not been satisfied that they were on the balance of probabilities obtained by torture, at the stage of assessing them later, the judge had, or the Court of Appeal rather, had said that the judge should exclude any reference to the potential that these were obtained by torture. So that piece of evidence was to be excluded when actually conducting the fact-finding exercise about whether the confessions spoke the truth or not, what you found as a fact had happened in terms of the bribery allegation. So the issue is about admission of evidence into an exercise of fact-finding, we submit, rather than going forward to make a decision without having found the facts, because ultimately the facts are being found in that case by reference to whether there is reliability on the confession, weight to be placed upon it, and therefore the facts that it reveals. That's the exercise that's involved, we submit.
Yes, but the statement in paragraph 97 is a bit more general than that, is it not?
My Lord, I should say we did bring copies in case the court would be assisted by any paper copies of that. I don't know.
I have one in front of me, and I imagine my colleagues may as well.
Yeah.
And what is being said in paragraph 97 is that it's talking about in Re B, but in effect it's in Re H and in Re B. It isn't setting up a general rule for the common law, and that in Re B is addressing section 31(2) of the Children Act. Now you may say, well, we are in an analogous circumstance here, and therefore it should be extended to this circumstance. But there is no common law rule that must, in all circumstances, follow in re H and in re B. You'd have to persuade us that we were sufficiently analogous to in re H and in re B for that approach to be adopted here. I think that is your position.
Well, my lord, we say it has been adopted here, but with that slight variation, yes, we submit it's been previously adopted, but we submit that, yes, that is the correct approach to follow in terms of fact-finding to inform the evaluation of risk. But, my lord, the submission we make about 97 is that the proof of the zero sum, as it were, for the proof of one particular legal rule didn't apply to the other legal rule, but that was still in the fact-finding exercise. The second legal rule is a fact-finding exercise from which it had been excluded because it hadn't been found as a fact earlier on. So you were removing the evidence in the global assessment you're making at the second fact-finding exercise. So that's the distinction we draw. That what we're talking about in this case is the Parole Board having completed the one factual finding exercise, but then in some way relying upon that which it's not found proven at that point, having weighed all the information at that earlier stage. Well, if I might turn to the parole cases, we submit that they demonstrate two things in the application of the principles which are in line with the first respondent's case in the Court of Appeal's judgment. Firstly, that the approach taken to unproven matters is not novel or a situation that has not yet arisen to be grappled with. The fact that there are allegations as well as convictions in a person's history has long been recognised and dealt with by the Parole Board. The second point is that they demonstrate an entirely workable scheme established over those decades, and no imperative has been shown to dispense with facts now. There's been no alteration in the legislation, no new provision to be interpreted. The Parole Board system remains both in its functioning and its purpose materially as it has been in the cases that have grappled with unproven allegations or previous unconvicted matters. By reference to our case, if I may, at page 95, we set out some principles as to the approach that the board takes. C on page 96 and over to page 98. And we submit these are well-established principles as to how the board should approach its task. The sole matter placed in issue by the appellant is Roman numeral 10 on page 97. And we submit that that issue is either determining what are the relevant or probative facts, which is one way of phrasing the question, or whether the Parole Board is indeed limited to facts, which is the other. The Parole Board, of course, formulates its case as the latter, that the Parole Board is not limited to what has been shown to be a fact. And that is understandable, because if phrased as the question, what are the relevant facts to take into account in your consideration, then the third standard of proof of possibility, or lesser standard than being probable, would be rejected on good authority. But we submit the two are not properly distinguishable as propositions. In both, you are giving weight or regard to what has not been shown to be a fact on a standard of proof of the lower civil balance. As to the pedigree of the requirement that the board functions on facts, I take us first, please, to the Sim case at page 1382. and this is within the judgment of Mr. Justice Elias, as he was.
Could you just give the page again, please?
Sorry, my lord. It begins at 1382. The actual passage, please, is at 1409.
Thank you.
1405.
09.
Thank you very much.
This is paragraph 60, to which she was shown at least part of that by my learned friend. I placed that into the context. His Lordship ending there, it's not simply a factual issue, talking about the evaluative exercise compared to the finding of facts exercise that precedes it. But whether or not His Lordship was suggesting in any way that the Parole Board does not proceed by establishing facts, one can see at paragraph 61 below that there were many findings of fact that were relevant, and you can see that just above letter F, the Parole Board consideration of accepted occasions he'd had a drink. This is the prisoner had had a drink but denied it. He had 3 separate warnings for that which he'd not challenged, and he'd accepted that he refused to take a breath test on certain occasions and refused to accept responsibility for the offence or undertake any work about it. So these were all facts, part of the process of the Parole Board forming a decision in that.
Well, nobody doubts that there will usually be lots of facts, Mr. Rule. The question is whether you're limited to things that are facts.
My lord, I was just demonstrating the fact in this case it's no different. If I go to 65.4, please.
All right.
Page 1411. The Parole Board is entitled to consider hearsay evidence. Neither domestic jurisprudence manifesting the doctrine of fairness nor Article 5 require it to be matter of cross-examination of witnesses to establish facts on which the Board relies. So the question and the Court's decision was to establish facts. You could rely on hearsay.
Well, are you really saying that we ought to take from Mr. Justice Elias that he supports your principal proposition in this case, that the Parole Board can only work on established proven facts? Is that what you're saying?
What I submit is it wasn't even suggested to the Court at that time that it should go beyond facts.
Well, what about the analogy with the bail application?
My lord, it's accepted not to be a perfect analogy, and it plainly isn't. The issue there was about what is information that can be admitted. So when talking about bail, the obvious analogy is in a bail situation, the court is not dealing with strict evidence. It's able to take into account the prosecution case essentially at its highest, unless there's some reason to doubt the information. So the proposition of a bail situation where you're at the beginning of a process, which in fact has a custody time limit added to it, but you're dealing there with inability to try facts. You're not forming a final decision. You are very much at the reasonable grounds to suspect type of scenario earlier in the Children Act. You're an early stage where you have suspicions that enable an arrest or a remand.
I understand all of that. What I'm getting at is that if you are asking us to rely on Mr. Justice Elias in support of you, what do you make of his words? The position of the Parole Board is closer to that of magistrates hearing a bail application.
Well, my lord, because in 2003, when he was making his decision, we didn't have enforced hearsay provisions in the criminal courts in general. He was talking about the information that could be received being similar to information received by a magistrate's court. It's not about the decision-making process in the way in which there's been a suggestion reliance might be placed on paragraph 60.
Okay, all right, thank you very much.
We place it in the context of a fact-finding exercise, and the question being, how do you go about that fact-finding exercise? Brooks, my lords, is plainly important, and the court has not spent much time with it yet. And I invite your attention, please, to that beginning. Well, if I go directly to the passage at page 588, please. This is the case, as the court knows, in which the allegation of rape was established before the Parole Board, despite the fact that the complainant was reluctant and there had not been a prosecution. It's also the case, as I referenced yesterday, considered in War Boys without any disapproval or disagreement. In that case, we first have Lord Justice Kennedy, on page 587, beginning with paragraph 27, His Lordship dealing with the Article 5 point that we looked at yesterday.
Excuse me, pause for a second. The public are not to interrupt and speak out in proceedings. Continue, please.
Thank you, my Lord. And my Lords, the reference at the end of that paragraph to the oral hearing in the context of an adversarial procedure. There's then the paragraph 28, which I think you were taken to already. In agreement with Lord Justice Kennedy is Lord Justice Wall, whose judgment includes the express reference to the re-H point. He expresses his agreement on page 600, paragraph 68, his agreement with the judgment of Lord Justice Kennedy.
What do you want us to take from paragraph 28 before we go to page 600?
You've seen 28, my Lord. This was about no burden of proof to the evaluative exercise.
Yes.
But the distinction, of course, between that not having the burden of proof and a standard of proof applying to the fact-finding exercise, that there's no suggestion, although there's dissent on whether the appeal should have been allowed, Lord Justice Clark, who would have allowed the appeal because he felt there should have been a witness summons for the witness, Lord Justice Wall, none of their lordships take issue with Lord Justice Wall's explanation of the exercise in which the hearsay is put to make the finding that the board did, which we come to at paragraphs 71 to begin with, please, on page 600. The issue of fairness cannot be divorced from the function which the board has to perform, even though not conducting a criminal trial. And then, particularly having looked at re-H at paragraph 76, at 70, so the references at 72 and 74 to reasoning upon which the board reaches its conclusions. But I go past that to 77, if I may, and the application of re-H.
So we skip 76 and go straight to 77?
At 76 is the reference to Lord Nichols in re-H.
Yes.
And in 77, his lordship says that approach has a broader relevance to the instant case than a simple application of the standard of proof. It had been cited, Lord Nichols has been cited by Lord Justice Kennedy on the standard of proof point as well. But Lord Justice Wall is express that it goes beyond that in its application to the parole board process that the court was concerned with in Brooks.
What argument is Lord Justice Wall addressing in these comments?
The prisoner's challenge in that case is to the use of hearsay in order to carry out the fact-finding exercise.
Yes, I mean, Mr. Fitzgerald was wanting the complainant to attend the hearing. Is that right?
They were actually wanting the evidence to be disregarded. No one had summoned the complainant, and that was regarded by some members of the court as a tactical decision on the part of the prisoner, which they wouldn't go behind. It was regarded by others as a possible misunderstanding of the board's power to ask for a witness summons from the High Court, because the board, as an inferior court, can't issue its own summons. But whichever way it was looked at, the actual issue was disregard it entirely because it's hearsay, and I haven't got a fair...
Not quite. Is the answer to my Lord's question not to be found in paragraph 70?
Well, precisely.
Yes, but that goes to the argument you should have disregarded it.
All right.
I accept the issue is about hearsay being used to make the fact finding, but that doesn't alter, in our respectful submission, the fact that since 2004, if not before, the approach has been understood that the board would operate on facts. And paragraph 78 in our respectful submission, that is perfectly logical and we submit correct explanation of the board's functioning and the way in which it must carry out its...
Well, in Brooks, they did find the facts. That's the whole point.
Yes.
They never got to the question of whether they could manage without doing it, did they?
My Lord, I, with respect, don't read paragraph 78 as limited in its application to whether or not in that case the board had found the facts or not. It's talking about the function and the process that the board undertakes in terms that differentiate between looking at the evidence and assessing that to establish facts on the balance of probability. This is at paragraph 78. In order to decide those facts, and it is then on the basis of the facts it had found to make its assessment and whether or not it's any longer necessary to protect the public to the claim.
Yes, that is a description of what they had actually done.
Yes. It's not addressing the question whether if they had done something else, it would be illegal.
Well, my Lord, if one takes from an omission to expressly be critical or otherwise of the fact, it's not, in our respect submission, expressed in a way that doesn't carry with it approval of the way in which the board has conducted that task.
But there's no question if the board can make findings of fact and does so, that is a more secure view taken. But this does not budge the proposition that the board can carry out its function without making findings of fact.
My Lord, that wasn't, of course, the question, as I say.
That's my point.
No, my Lord, I accept that, and what we say about that is it's always been implicit. It has never been suggested that the board should operate on another basis than facts.
Yes,
but with that submission in mind, it's also relevant the court was saying that it is then to the evaluative exercise, not eliding the position so that fact-finding isn't given the proper regard it should be, but it is then on the basis of the facts found it makes an assessment. And what we don't submit is irrelevant, is the suggestion that is on the facts found. And I appreciate, of course, that there was no argument that it should be rewritten to say on the facts found or on other concerns it might have from non-facts, that it is not so found.
Thank you.
My Lords, you also haven't been taken to the D and Northern Ireland case. On the Learned Friends submission, it doesn't have any bearing because in that case, again, the Parole Board had carried out a fact-finding exercise. And so because the primary issue was whether that burden should be raised, that standard rather should be raised, and it should be a heightened civil standard being applied rather than the ordinary civil standard. That having been rejected, the Learned Friends suggests nothing is gained from this decision, but we submit precisely because the decision rests on the civil standard being the requirement, it cannot be placed aside so readily. This is House of Lords authority with unanimous decision considering a Parole Board case in the Northern Ireland context, the equivalent, in which there had been an allegation which the Parole Board had looked into as part of its decision-making. So, firstly, my Lords, if I may, this begins at page 510.
Thank you.
And the first passage that I go to is, in relation to the legislation, before I perhaps go to the dicta, it might be worth just drawing the comparisons for you with the English legislation. This is the Northern Ireland case.
510.
So, my Lords, we can see the legislation dealt with, firstly, at page 513H in paragraph 6. At the bottom of the page, penultimate line, under Article 6 of the order, as soon as a life prisoner has completed the tariff part of his sentence, the Secretary of State has to refer his case to the Commissioners, who must consider whether it is necessary for protection of the public from serious harm that he should be confined. If they are satisfied it is not so necessary, they are to direct his release. The wording, in fact, I've been back to the order itself, is identical to section 28.6. So that is what's being expressed here. The other relevant provisions are referred to as Article 9.4, which is at the bottom of that paragraph, the case of such prisoners to be referred following a recall under Article 9.4 to the Commissioners to consider whether he should be released and direct accordingly. Exactly as Section 32 of the Crime Sentences Act did not specify on a recall case what the test was, it was the cases that said it's the same test as Section 28. This Article 9.4 is the same terms again. So again, the court is, as with the English cases, saying there's no difference which test you apply. It's the same test whether you've been recalled or it's an initial release.
So this expression of it here is Lord Carswell's shortened summary.
Yes, yes. But in essence, those 2 points, one has identical provisions in the English and the Northern Irish. There is one point which is slightly different, which my Lords will remember yesterday, as we went through Section 239, I asked you to note a part that dealt with directions the Secretary of State gives and factors he takes into consideration. It's slightly different in the Northern Ireland context. There is an Article 3.4, which is referred to here, which refers to the Commissioners having due regard to the need to protect the public from serious harm and having regard to the desirability of preventing the commission of offences or of securing rehabilitation. So rather than the directions the Secretary of State would give having regard to them, the Commissioners also have regard to them. We don't submit there's anything relevant of distinction in that, but it was relevant that I helped the court with the differences in the legislation, I hope. Now, with that background, that it's essentially the same test for release that the Parole Board in this jurisdiction considers, at page 515, one can see what the decision was of those the commissioners, the life sentence review commissioners, as they are in Northern Ireland or were. Paragraph indented 49 on page 515 at the bottom. We are satisfied on the balance of probabilities that D sexually abused L and G, and this abuse included repeated and forcible anal penetration, etc. Furthermore, it's our opinion that, as at the date of his recall, that conduct was indicative of a significant risk of him committing serious harm, for example, the sort perpetrated on them, if he remained at large. So they've made the fact finding about whether he's committed the offences, the allegations proved, and they apply that fact to the future assessment element. Now, in the dicta, the court, as I say, dealing with the grounds on which there was a challenge to the way in which the process was conducted, and there were 3 grounds that are set out at paragraph 15 on 516, but relevant for present purposes is to turn to 518 and paragraph 23. At 518F, the court was regarding as indisputable only 2 standards are recognised by the common law: proof on the balance of probabilities and proof beyond reasonable doubt, which is these days perhaps considered trite. But that was certainly affirmed in that case. And then at paragraph 26, Lord Carswell is dealing with not only having looked at Re-H, in paragraph 25 you can see an example of that, but also at 26 looking at Raymond, one of the SIAC cases, and to which this court's been referred. And in what the House of Lords held in Raymond, again, there's a suggestion that the House held that where past acts relied on, they should be proved to the civil standard of proof. And then at paragraph 29 on page 521, having recognised the way in which the commissioners should go about their task, and it being the civil standard of proof for the facts of the allegation that were to be relied on, at letter D on page 521, they considered the case put forward by the respondent, the quality of his evidence, expressed themselves satisfied after most careful scrutiny that he was the perpetrator. They were clear in his minds he committed the grave sexual assaults. And in my opinion, they went about their task in the proper manner. The criticism made of their approach was not justified. The evidence against the respondent was clear and cogent, pointed very strongly to the conclusion reached by the panel. So before their lordships, the House was unanimous that the proper approach had been followed, where there had been an exercise faced with an allegation of deciding it on the balance of probabilities. We submit it's inconsistent with that to submit that you can use an allegation in the process without subjecting it to at least the balance of probabilities approach. My Lords, we went yesterday to War Boys on matters of what it was legally deciding. In terms of its analysis on the point about looking at the facts to make findings the information to make findings, could I draw your Lordship's attention to 2 paragraphs, please, in that judgment? Page 629. Paragraph 44, Brian Levison was looking at the questions that might be asked of Mr. Warboys on the basis of the information, and they would include, just in 5th line down towards the end, whether his offending or any inappropriate sexual behaviour short of the commission of crime was indeed confined to the 12 victims in relation to whom he was found guilty. So there's no suggestion in the questioning that you could not undertake an exercise that looked to find whether his offending was wider than the conviction record. That's consistent with Brooks, consistent with D in Northern Ireland, that the use of material, the information, is with a view to relevance. And the sort of information that the court had in mind, you can see at 54 on page 632, that would have been putting to use the rape kit and other items, exhibits that had been found, incriminating items, matters that had been considered by Mr. Justice Green.
Which paragraph were you at?
Page 632, please, my Lord, paragraph 54.
54, thank you.
And this is really the context to the decision about what material there was and what use it would have been put to, in the court's view, had it been obtained in War Boys and had it been looked at as it should have been to evaluate his attitudes. So part of probing and testing would include finding facts from that process that would reveal offending, reveal allegations shown by that process. Delaney, the court's looked at already and seen the passages, and the point my Lord's made to my learned friend was the amount of evidence available in that case. The key point and the reason the claim succeeded was the Parole Board's declining to make findings of fact about the events which it factored into its decision making. It wasn't a question about whether there was other material or enough material, but it was a question about the fact that it had gone beyond that to rely upon the mere fact of allegations, or the unproven allegations rather, in the course of its decision making. My Lords, the case of Morris next, please, and that is beginning with the first reference I'll make, please, on page 685. This is the case of decided by Mrs. Justice McGowan, which remains outstanding on appeal. It is stayed behind this case, and it's the case in which which Mr. Justice Bourne relied to decide that the guidance was lawful, but the Court of Appeal is critical of. And in our submission, the Court of Appeal was rightly critical of the decision in Morris, and we would seek just to demonstrate some of the errors that one
was rightly critical.
I'm sorry, Lord.
Did you say it was rightly critical?
Rightly critical, yes. Yeah. The Court of Appeal rightly critical of this judgment for the following reasons.
Thank you.
If one turns, please, to page 685, you see a title which Her Ladyship gave to this part of the judgment, Matters Which Have Not Been Proved. We submit that was an erroneous title, and it factors into the reasoning that follows. What it should read is not proved previously in court. When we talk about the cases she's about to come to, it's matters not previously proved in court. They were proved, as the court was just taxing me on, in those cases, Brooks and others. And in fact, one could add the words to the title, and those proceedings were binding on the prisoner. That's the War Boys situation where Mr. Justice Green's determination against the Metropolitan Police was not binding on him, although facts had been found by the High Court that he was guilty of those matters. That was not binding on him because he wasn't a party to those proceedings. So what should be being considered here is matters not proved previously in court in proceedings that would be binding on the prisoner. The judgments that are referred to under the title of matters not proved, in fact, are Brooks at 40, McGettrick and War Boys. War Boys, of course, was at the earlier stage of what needed to be considered rather than what had or hadn't been taken from the judgment. But Her Ladyship goes on in her discussion and her decision at paragraph 51 to say the third issue is whether the board was required to disregard two allegations, one of harassment, one of assault, because they had not been proven as a matter of fact. In my judgment, this point has been decisively addressed in previous authorities. We submit with respect that the authorities had not previously, on any occasion, established that the parole board was entitled to proceed on matters not of fact. At the bottom of the page, still paragraph 51, the bottom of 688, Her Ladyship refers to the burden of proof having no real part to play. That is, of course, a reference back to authorities that were dealing with the evaluative exercise, whether the burden of proof applies to the decision that you're taking. Is Section 28 involving a burden or not? And as Mr. Justice Bourne said, and as the Court of Appeal agreed, that is not concerned with the fact-finding exercise. That is a comment concerned with the evaluative exercise. So the misuse we submit by Her Ladyship of that comment as if applicable to the fact-finding stage.
So in the fact-finding, on whom does the burden lie?
There is no burden on an individual. There's a standard of proof. So the board is inquisitorial in that process.
The burden of proof is irrelevant because it's not an adversarial process. It's an inquisitorial one.
Entirely. And the nature of the decision it makes has never been said to impose a burden on either party. So, my Lord, we submit that's fundamental to the decision that is reached as to what the law is in terms of dealing with facts or not in a parole context.
So the burden of proof is wholly irrelevant to any aspect of
wholly irrelevant. Yes. The standard of proof applies to fact-finding, civil, but no burden. Yeah.
Thank you.
Then Her Ladyship's made those remarks that we submit don't withstand analysis of those cases at 51. At 53, we see her adopting a different standard of proof to any known to law we submit. Paragraph 53. This is where the mere allegations point really arises and the difficulties that the court was discussing yesterday in terms of definition of any such matter, because Her Ladyship is beginning to look at that, and rather than finding that there had needed to be the standard of proof of a balanced probabilities, we have in the middle of paragraph 53 the board finding that there is a significant chance, slightly above the middle, significant chance short of probability that a given allegation was true, legitimately considering that. So this is the way of phrasing the question as a third standard of proof.
Well, I wonder about that because, she starts the paragraph by saying that the allegations cannot be proved. So she's not talking about a different standard of proof. She's talking about something other than a fact-finding exercise where you have to weigh up possibilities, and you obviously attack that. It's fundamental to your position that the parole board is not entitled to do that. But I wonder if she's actually setting up a different standard of proof. She's merely saying that you can have regard to possibilities without finding fact.
Well, my lord, I don't want to repeat the submissions I made about the way in which one formulates this. We respectfully submit you can formulate it as a question of standard of proof to a fact that's relevant and probative, or you can say it's about what is not a fact because you've set aside that requirement and you went some other way taking into account the same matter that is not a fact. So I accept that one...
A fact, but that itself is an artificial construct. What you're saying is, not whether it's a fact, but that it's got to be more likely than not to be true. I mean, the fact that it's 51% likely to be true doesn't make it a fact, except when it's deemed to be so for the purposes of civil proceedings.
Well, my lord, yes, but we submit that that's...
shorthand for a standard that it must be more likely to be true than not. Even though it may well not be true, if it's more likely to be true than not, it can be had regard to.
My lord, absolutely, that is the system of binary, it's a fact or it's not a fact.
Yes,
and the
you're
reason...
applying that to this.
Well, my lord, in my submission, it applies to all decision-making for good reason, because in the absence of that, you're not in a position to actually decide on what building blocks, what basis you're forming your judicial evaluation. And that's why the law requires this, and I accept entirely artificial, it's either a fact or not, because it met a standard. But the law has been clear about two standards only, and you have to meet that standard to be the one factor rather than the zero factor. And that binary approach has to remain consistently applied, we submit, for good reason, because it enables decision-making, and it enables fair decision-making because an appropriate standard has been adopted. In this case, in Morris, of course, the board is relying on matters which it hasn't found proven. So this is the first example you can see of a case in which there is reliance placed on that. And the way in which that happens, you can see acceptance of that in the middle of 54. The board made clear it did not find the allegations from 2014 or 2017 proved. Then there are certain facts which would be consequential, collateral, micro facts, which could be taken into account. The difficulty comes in taking into account from certain facts the entirety of the allegation, because you move on to paragraph 55, it's not a mere allegation. And we submit the Court of Appeal is right to say that the gloss added below the indented citation from Andrew Baker, Mr. Justice Andrew Baker's judgment in Delaney, the gloss added is not warranted. And as you follow over the page, you'll see that the learned judge is saying there needs to be some evidence that allows the court to decide whether the allegation has some factual basis. And that's the point I adverted to earlier this morning when I talked about the difference of some factual basis or some evidential basis as the issues formulated in this case. What you then have in Morris is a good example of what we submit is unfairness in operating from certain known facts to simply then operate on the assumption of the wider facts themselves. So for the two allegations, the 2017 allegation was one of harassment by making telephone calls. In that regard, the court takes into account factors that you've seen. You were taken to paragraph 56 already by my learned friend, and you see in that paragraph references to how the court is suggesting the board could use the information. So relying on the fact of his arrest at the time. The second point is not controversial. Admission things became verbally heated. Knowledge of the existence of a retracted statement and relevant police reports. This is all in relation to the assault. So arrest at the time, knowledge of the existence of a retracted statement and relevant police reports. None of that material was actually before the board. It's the fact of its existence that the court says is enough to work on for some probative value. In relation to the harassment allegation, it's entitled to rely on knowledge of the existence of police statements, in particular, the prevention of harassment letter. We are bound to assume the police sent it in good faith, with a proper basis in fact, having detected a risk that the claimant might commit acts of harassment in future. Well, the harassment letter was expressly a warning about future conduct and made no, expressed in its terms, it made no findings of fact about whether you had or had not committed an allegation, and you were not in any way required to admit that when you signed the letter. It's a warning to enable a prosecution in future to say you were on notice about that. It was a breakdown relationship in which there'd been some telephone calls. What level they...
Mr. Rule, I have to remind you, you've got 15 minutes to complete your submission. I don't think it will be productive to run an appeal against the Morris decision in detail. I think you need to cover your ground as best you can.
My lord, yes. I leave it there with that kind of indication. The point we advert to from that and from other examples is the unfairness when you leap from one fact to the full allegation. If I can give the court reference to that, you have worked examples that the Court of Appeal gave, which are set out on page 162 in Lady Justice McCur's judgment at 44 to 46. You were taken, I think, to sum of 46. Those three paragraphs in our submission are correctly indicative of use of relevant material from the allegation that's being considered, the information that's being considered, and that which is not permissible to leap from one fact to another unknown non-fact. And we set out further examples in our statement of case at paragraph 18, which you find on page 104 to 105, concerning the details of an example of an assault that we give there. So I refer to those, if I may, for the court's assistance.
Cover the ground. If you have to refer by just simply give us references, please feel free to do so.
Well, I'm very grateful. I am pressed for time, and I will do my best.
Well, I appreciate your effort.
Well, the Re-H case, we've been to the minority view of Lord Brown Wilkinson. What we've not looked at was his passages on microfacts and macrofacts, which in fact directly follow those where he was giving the air raid example. For your note, my lords, I don't go to it now, but you know the point I make about it, that the distinction between the micro and the macro facts in the weighing up of a risk. That's on page 537, letters C to G, and he uses the term macro and micro for differing facts.
Thank you.
Lord Lloyd was the other minority member in the House in Re-H.
You said 527. That's the
537.
537. I'm so sorry. Thank you.
Lord Lloyd's judgment we ultimately accept is more difficult to reconcile with the majority or with the approach that we say is the proper one. But we do note that his lordship agrees in certain places that the found individual facts are what give concern for the future, differentiating the abuse point from the past. He cites Lady Justice Butler-Sloss to page 543 D to E on the finding of facts to give concern for the future, and he agreed the standard of proof of past acts must be on the balance of probabilities, was open in fact to that being higher standard. That's now been put to rest, but it is not a reconcilable judgment we accept with the majority and with what the proposition is that we submit is the correct one. Lord Nichols giving the majority, with whom Lord Gough and Lord Mustill agreed, it is very clear about a conclusion based on the facts. The court has that as the title to his starting point. As Lord Hamblin mentioned yesterday, the general principle starting point at page 553. In the dicta which we have adverted to in our case, and adding slightly to that, if I can give the court references, the first point we take from Lord Nichols is that you cannot act on suspicion. Judicial bodies don't act on unresolved doubts or suspicions. References at page 553 D to E and 554 E and 555 C to D. The last referring to an imposition of a burden of proof in effect by requiring allegations to be disproved to remove all possibility. The second point we draw is the future likelihood being inferred from the found facts. References 554A and 554B. And a point previously made at the final determination to be satisfied, needing the fact-finding exercise, drawing a distinction with the reasonable cause cases, and you were taken to some of that dicta at 589F, at 553, at the bottom, 553F to 554A, and D to G on the same page, 554.
Thank you.
Re B, my lords, I'll ask the court just to note Baroness Hale in that case. This is the case in which my learned friend has cited Lord Hoffman at paragraph 3, talking about perhaps other situations where the re-H approach might not be appropriate. In that dicta, there is a reference to future inferences from facts, which we submit makes that passage slightly difficult in its meaning. Inferential work, inferences, of course, leads to facts, which are found as a fact inferred from the prior fact. We submit there's no difficulty with an inferential approach to decision making, and his comments may be best understood by reference to the past harm abuse point with the child rather than a more general one. But in any event, even if the obiter dicta suggests that there may be cases in which one doesn't apply the same approach, the lack of examples of that the board is able to provide you with in our submission is telling as to whether or not it was a prediction that there would be good use to non-facts in other situations. The references in Baroness Hale's judgment, to which I draw attention, please, the one standard of proof for facts at page 787G to 788A, that's paragraphs 22 to 23, she says, explaining that one answers whether there is a likelihood of a significant harm in future as a prediction from existing facts about what's happened in the past, which have to be proven on a balanced probability. And it wasn't enough, there was a real possibility. The judge had apparently set up the appeal with the basis of his finding that there was a real possibility of the abuse having happened, but he couldn't go to a balanced probabilities. That wasn't enough. And paragraph 54 on page 795 to 796 deals with the is in the risk assessment. So inverted commas is, not might be, risk. And again, referencing Lady Justice Butler Sloss at paragraph 50 on page 794 F to G. And 55, I took my lords to earlier. Re J, another case in the trilogy that deal with the Re H case in our bundle. You were taken to that by my learned friend on Lord Reed's obiter dicta at paragraph 93 on page 866. We submit the context to the criticism that perhaps there's been, that the Re-H had been unfortunate in its consequences, was where there was findings of split hearings being made and preliminary issues that separated out the relevant facts into sole compartments, and that had been the problem. Lord Wilson expressly disagreed with Lord Reed in any event at paragraph 71 on page 860H. And Baroness Hale at page 856 C to D referred to, again in keeping with her earlier dicta, to the objective factual basis required to draw the inference of future harm in her dicta at paragraph 49 on page 856. The SIAC cases, my lords, and I appreciate I'm into the last 5 minutes essentially.
You are.
My lords, the SIAC cases, you have Raymond, of course, in the core bundle, beginning at page 693, which we've looked at to some extent. You saw in Re D Northern Ireland that Lord Slynn's approach to finding the facts, the past facts on the balanced probabilities, rather than, if there be a difference, the approach that the Parole Board refers to from Lord Hoffman, is is within the majority, and in Re D they regard that as, well, the difficulty with the majority is Lord Hutton agreeing with two people, but the principle is it's accepted in Re D that is the outcome of the Raymond judgment, and we would place reliance on paragraphs 22 and 23. You've seen most of 22, but we would say 23 also, page 723 to 724. The issues, of course, in the SIAC case is all being about conducive to public good, institutional competences, being a wide discretion and one for the executive rather than the courts, in the sensitive field of national security and public policy and democratic accountability. And as Lord Sumption's pointed out since, it did not involve a judicial body or ECHR rights or common law rights as recognised. We cited that in our case. In Lord Hoffman's judgment itself, we would invite attention to paragraph 54 on page 733, talking about the factual basis having to be established. And on Lord Hutton's dicta, which you were taken to previously, paragraph 65, page 736, there was suggestion of a high degree of probability of an individual act did not need to be proved. That, of course, includes the inappropriate civil test in part of his criticism, which may be why Re D reads Lord Hutton as agreeing with Lord Slynn in the approach to past facts. Begum, my lords, just very quickly, if I could invite your lordship's attention to a passage in that particular case on page 1009. This is a case, as we were told, she was shown yesterday, in which Lord Reid refers to Lord Hoffman's approach as being more orthodox. But that has been read in its context, we submit.
Which paragraph?
It's page 1009, please, my lord, paragraph 71. That the court has talked about separation of powers, democratic accountability, and that there's not a primary decision maker in SIAC when it's coming to this decision, limits of the appellate process and all the other factors. But what is said at 71 is nonetheless, even without a primary fact-finding or decision-making responsibility, the way in which SIAC would be able to review even the executive body's decision here is including a second option just above letter E. One of the things SIAC would conduct as a function is consider whether the Secretary of State has erred in law, including whether he's made findings of fact which are unsupported by any evidence or are based upon a view of the evidence which cannot reasonably be held. So the importance there is to recognise that even on the review process under the revised SIAC appellate legislation, there is an error of law to make findings of fact unsupported by the evidence. We submit that is indicative of a general principle that facts are important to the decisions being taken. If one can, for example, have a challenge to an incorrect factual basis because there's a lack of evidence to support the factual finding, it's difficult to reconcile that with a proposition that one could have decision making even in SIAC situations of national security, etc., where one was willing to allow a decision to be founded on matters that had not been shown to be a fact. I appreciate the two things are not the same point as such, but the difficulty of reconciling why one would be an error of law and one would not in our submission is real. In the remaining 2 minutes, I think I calculate, my lord, that I have, the Court of Appeal, the Parole Board guidance, firstly, could I just invite your lordship's attention to Appendix 2, Part 1, Part 2 rather, the appendix. You've looked at this from a learned friend, for which I'm grateful, but could I just point out where there are some differences that we submit are relevant. The first is to recognise that this is talking about three ways of approaching a matter of allegation, a fact of an
page number.
Sorry, my lord, page 431.
Thank you.
You had paragraph 6C and paragraph 9 over the page 3, which are the third way. It is the third way that we take objection to. And we submit that it's relevant to note why you arrive at the third way can be because it's unfair to undertake the second way. I'm referring there to under the heading Findings of Fact 11 and 12. fairness is, the Parole Board challenges the respondent's case on whether fairness is really an issue. We submit it's recognised within the guidance that the fairness of the process is an issue.
What do you mean by fairness in this context? It's been put to you by the Parole Board that Lord Justice Singh has said that public law fairness equals our concept of breach of natural justice, not substantive fairness. The word fairness is thrown around in some of these cases. What do you say it means?
We distinguish cases like Talpada, which are concerned with substantive unfairness, as it was understood, as cases about extraneous matters being said to render a particular approach unfair. What we are concerned with in this case is the judicial decision being taken by reference to only the matters that are fair to take into account, by approaching its task in a fair way, and we submit it's unlawful to take into account matters that have not been shown to be fact.
So you're saying that it is unfair not to have the two-stage process in a nutshell?
Our primary case is it's intrinsically unfair for any judicial body to determine a question by reference to what is not a fact. That's our primary case. If intrinsic unfairness, and there is some debate, and I accept entirely, my learned friend takes you to the Court of Appeals judgment and criticises the use of the word public law fairness, but in fact we would submit, if you read those two paragraphs in which there's a reference to that by Her Ladyship, which are set out in the Court of Appeals judgment, you'll see that she's not relying on a concept of public law unfairness in some specific way. She uses inverted commas over the very wording in one of the two passages. What she's referring to is the intrinsic unfairness, which she's found as a matter of law from taking into account matters that are not fact.
But intrinsic unfairness, other than public law unfairness, is not a ground of judicial review.
My Lord, if it's phrased in a judicial review context, and we would submit we're talking about a court acting fairly and its duty to act fairly, and that may be slightly different. But if one's talking about the common law procedural fairness, one has procedural impropriety or a breach of natural justice, we submit that is the process of not taking forward only the facts found to your evaluative exercise. That is a process that we say is of universal application. There's no difficulty to applying it as a rule applicable to all of the procedures for a parole board to fairly undertake.
Thank you.
And if the categories of unfairness are of course not closed, you see that in Lord Justice Singh's judgment at page 1448. And we also draw attention, if it assists the court, on the classification, as it were, of what we identify as the error of law. You have Lord Stayne in Venables referring to the Home Secretary giving credence and weight to public clamour to increase tariffs as a procedural fairness flaw. Pathan refers to that, Lady Arden, at page 1323, paragraph 38.
Page again?
Page, my Lord, 1323.
1323.
Yes.
Thank you.
And we've included in the bundle also, I don't ask the court to go to it, the E case, in which Lord Justice Carnwath, as he was, deals with material breach of natural justice being an error of law. Paragraphs in that case, 38 on page 757D to E, 46, paragraph 46 on page 759, and 47 on the following page 760, and paragraph 63, page 765. This was a case that famously deals with mistake of fact as a ground for judicial review or legal error. We submit again the same point about a mistaken fact being a ground for error of legal principle. Having operated on a non-fact must equally be seen as justiciable. And the last reference on this point is Lord Reid in Begum, paragraph 71, referred to an error of law to make findings of fact unsupported by any evidence, which was what I took the court to earlier. So we do submit that legally it's not difficult to hone the case, as it were.
So the Begum reference, please.
My Lord, that was paragraph 71, and that was on
1009.
Thank you, my Lord.
I'm afraid to say your time is now up.
It is.
But we will consider everything that you've said in your written case, as well as what you have said to us already.
I'm grateful, my Lord. We set out in detail our summary of the Court of Appeal and our position on the guidance.
Thank you very much. Yes, Mr. Collins.
My friends touched on the expression mere allegation, which I was asked about yesterday. And the board's position on the expression, broadly speaking, is that it's not a helpful one. An allegation is information to which a panel may have regard. It is for the panel to consider whether the allegation is relevant, and if so, what weight to give to it. It may be, to use an expression that my Lord Kitchen used this morning, a fact of no probative value, but it's for the panel to determine what, if any, probative value it has. And when it makes that assessment, it will have regard to the sorts of factors which I took the court to yesterday at paragraph 20 of the guidance: source and supporting information, nature of the allegation, and so on and so forth. I mention supporting information among that because the question of corroboration cropped up yesterday. There's no requirement that there be corroboration either in the technical or the non-technical sense. But where there is supporting information, of course, that may assist a panel in determining the reliability, the weight to be placed upon the content of the allegation. And of course, the context will also be important. I don't want to spend longer than is necessary on enemy aircraft. But can I say this? All the submissions you heard about Lord Brown Wilkinson's metaphor from a learned friend this morning really said that what one has to do is to put an allegation in context. And of course, that's inevitably right. That the panel will look at the surrounding circumstances, starting, of course, with the offence for which the prisoner has been sentenced and his criminal record, but of course all the other matters which are before it as well. So it's a matter for the panel to assess the allegation, subject always to review by the courts on grounds of rationality, and we say that is not a two-stage process. It is a single exercise of evaluation which involves assessing all the information and attaching weight to that information which is found to be relevant. That exercise may include finding facts, but it does so as part of the exercise of evaluation. We say it's not a precursor or an earlier stage to that. It's what the Divisional Court in Warboys called a global assessment of risk. Paragraph 150. The court asked this morning what the board meant by referring to the evidential basis for an allegation. The expression factual basis is also used. Neither of these is intended to be a technical term or a term of art. What it means is that the decision must be founded on the information which is before the panel. My learned friends just referred to Begum and the reference to Lord Hoffman's, what's described as more orthodox in public law terms, identification of the relevant questions, the first being whether the evaluation had a proper factual basis, or as he put it, whether there was no factual basis for the Secretary of State's opinion. And that's the reason why the board has identified an evidential basis or a factual basis as an ingredient in the decision-making process. It's simply that proposition that it's necessary to show there is some basis upon which the decision is taken. My only friend of the last few minutes has referred a couple of times to the proposition that a decision must not be unsupported by the evidence. And of course that's right, but unsupported by the evidence doesn't mean the same thing as not supported by facts found on the balance of probabilities. And that's a gap, we say, in much of the reasoning that's been put forward on the part of the first respondent. So by way of example, you heard yesterday submissions on Considine. And as I understand it, my learned friend says that Considine means that there must be findings made to the civil standard. But Considine isn't a case which addresses that either way. It's a case about assessments of dangerousness in the criminal courts. The passage you were taken to, and I don't ask the court to turn it up now, it's paragraphs 36 and 37. That tells us that there's no distinction to be drawn for the purposes of the dangerousness assessment between evidence adduced before the jury and evidence or information which comes before the court through some different route, and that what is necessary is simply for there to be a fair analysis of all that information. And the proposition that the Divisional Court in Warboys took from that, paragraph 151, is that the sentencing judge is given considerable latitude as to the range of information to be considered, subject always to considerations of fairness.
What was that paragraph number?
151, my lord.
Thank you.
Page 654. So it's a case about the breadth of information and the latitude as to the range of information to be considered. It doesn't begin to be support for a proposition that findings of fact must be made on the balance of probabilities. My learned friend took you to Mr. Justice Elias in Sim this morning. And one of the points that was flagged up by the court was that he suggested that in fact the role of the board might be a little closer to that of magistrates hearing a bail application. Can I ask the court to look at Sim and what Lord Justice Keane had to say about bail applications? It's page 1432. Paragraph 56. Just above H, his lordship said this: as to common law fairness, there is considerable authority which establishes that it is not necessarily unfair to admit hearsay evidence even where the deprivation of liberty is at stake. See Director of Public Prosecutions and Havering Magistrates Court. In that case, the Divisional Court had to consider the position under Section 7.5 of the Bail Act 1976, where a justice before whom someone had been brought after arrest for suspected breach of his bail conditions has to grant bail unless of the opinion that a person is not likely to surrender to custody or has broken or is likely to break a condition of his bail. Lord Justice Latham took the view that this required an assessment of the relevant risk, and that the material on which a justice was entitled in domestic law to come to his opinion was not restricted to admissible evidence in the strict sense. Can I ask the court to read that quote from Lord Justice Latham's judgment, which runs from B to D? My lords, the process which is envisaged there is one of evaluating the material in light of the serious potential consequences to the defendant and forming an honest and rational opinion. It's not a process of finding facts on the balance of probabilities. And what Lord Justice Keane says at paragraph 57 is, that passage seems to me to be generally applicable to proceedings before the Parole Board when it is assessing risks. So in our submission, my learned friend's wrong to say it's never been suggested that any approach other than that in Re-H could be applicable to the board. My lords, the last matter which I propose to touch on in replies, questions from my Lord Hughes this morning about what the board is to do in circumstances where there are pending criminal proceedings. And that the subject matter of those proceedings may equally be the subject of consideration before the board. And in one sense, I agree with my learned friend on this, it will depend on the circumstances of the case. The difficulty for the board, of course, is the starting point is that if it is not satisfied that there is a no more than minimal risk to the public on release, it cannot release. It may be that a board is able to proceed on the basis that it can deal with other facts, surrounding circumstances, material which will not require the prisoner to answer questions which might prejudice him. But this, in one sense, is a question of procedural fairness as to whether the prisoner will have an effective opportunity to matters which are relied on against him. And a prisoner may well argue, I can't properly deal with this because I can't answer questions. And so it may be that there's a procedural fairness or natural justice issue which might arise, but it will be a decision for the board to balance the interest of the prisoner and the system in having the case heard expeditiously, but ensuring that a fair process can be followed. I know the court asked whether there was guidance on the topic. There is guidance available on deferrals and adjournments. It touches on this issue very briefly. We can make it available, of course. I haven't yet had the opportunity to share it with the other parties. If it'd be helpful to the court, of course, we can make that available. My lords, unless there's anything further that I can assist with, those are my submissions in reply.
Thank you very much. The court is very grateful to counsel for the presentation of the cases in this important and significant appeal. We're grateful also to those who have assisted counsel in the preparation of those cases and in the preparation of the documents for our consideration. We will try to produce a reasoned judgment in due course.